Oh. Well, good afternoon, everyone. We are almost at the top of the hour for this webinar today. We are pleased to present you our first webinar of 2023 that's going to focus on the basics of the legislation passed that benefits all of you as agritourism operators, explaining the legislation and how it's been implemented. And with us today, we have Timothy Riley, an attorney with Dean Mead. He's been long supportive of the association and has a fantastic background. I only recently learned, Timothy, that you also practice oil and gas law in addition to land use and environmental law, and that you had lived and worked in Texas for quite some time, working for various local governments there, entities there. But Timothy has been a Floridian. He came to Florida in 2008 and also serves in our Army National Guard with the 83rd Troop. We're the 83rd Troop Command, and only recently finished a 16-month federal activation in response to Florida's COVID-19 response. Timothy is also an adjunct professor at Florida State University, teaching oil and gas law. So with that, I'm going to pass it over to Timothy to take it away. Let's see, Sarah, if you could moderate questions, how would you like to give the group instructions of how to participate?
If you'd just like to put your questions in the chat, I'll keep an eye on it. And when there's time, we'll get back to the messages and I'll read them out to Timothy.
Okay, well, thank you for joining us today, Timothy. Take it away.
Thanks, Lena. I'm very excited to be here. It's always good to talk agritourism with agritourism operators. I've been working with Lena and Sarah and the association since, technically before the association was even formed, and have a special place in my heart for farmers and ranchers and agritourism operators. And what I want to do, I understand we got like half an hour. So I have a handful of slides I kind of want to go through and talk a little bit about the legislation that recently was passed, but in the broader context of how agritourism and agricultural classifications sort of work together. And that was the thrust of the legislative change last year. So I kind of wanted to put that in context. And so the lens in which I look at that is through the as an attorney, is to look at it through the statute. So I kind of wanted to do is talk about agritourism, talk about the designation, the value of it, talk about your agricultural classification, your Greenbelt through the statutes, not to just simply walk through the statutes, which you probably know a fair amount as folks operating in this industry sector, but really highlight those key distinctions in connections between Chapter 570 and Chapter 196 as it relates to your agritourism operation and your underlying farm or ranch operation. Talk about that overlay, and that overlay is in the common problems that we see. That's kind of where the legislation was intended to address those problems last year, and talk about some best practices I see with the clients that have been successfully navigating the work in between your operations and property appraisers. So that's what I want to do. I want to do it in a relatively short order to leave as much time as we can for questions and answers. Again, just a little bit about myself. I've been practicing law in Florida for 15 years, primarily in the area of government relations, administrative law. Basically, I help property owners, agribusinesses, farmers and ranchers deal with their problems with government. I'm licensed in Florida and Texas. I'm one of the few oil and gas attorneys in the state of Florida as well. And I represent the full spectrum of agricultural clients. I got the largest landowners, farmers and ranchers in the state, down to 3-acre and 5-acre micro farms. So represent the entire spectrum of folks here. All right, got to do the malpractice thing right up front. Disclaimer: what we're going to be doing is giving information. right? Don't anybody go out there and do something saying that my attorney, Timothy Riley, who I saw on a webinar, told me to do this, right? Don't do that. This is information they're providing. You know, the circumstances that you may be dealing with in your particular property are going to be fact specific. They're going to be county specific. You know, make sure that you take this information for what it is. It's information to help guide and direct you. If you've got specific problems or concerns, you know, please consult your attorneys on a case-by-case basis. So again, let's talk about agritourism. And first off, what it is. And again, you're all agritourism operators, so you don't need me to regurgitate what the statute is in 570-86. But what I want to do is highlight those key terms that are particularly important when you're dealing with the property appraiser year over year to either preserve your agricultural classification or get an agricultural classification on your property. So when we look at the definition of an agritourism activity, there are 4 key terms that are important when you're dealing with your Greenbelt. And that's first off is agriculture related activities on a bona fide farm where you're allowing the members of the general public to view and enjoy activities. So the agricultural related activities, the bona fide farm, and the participation of the public. Those are going to be the key elements that come into play when we start talking about your agricultural classification, keeping your Greenbelt active on your property. We also know about in the red, you know, the proviso that's built in the definition that says agritourism activities doesn't include additional structures or facilities intended primarily to house, shelter, transport, or accommodate the public. The intended primarily is an important term, and we'll talk about how that comes into play when you're talking about your Greenbelt exemption. But it's something I want us all to keep in mind. And a lot of times we forget about the definition of an agritourism operator. It means a person who is engaged in the business of providing agritourism activities. And engaged in the business is a really important term because that crossplay when we talk about your Greenbelt is important. Not every farmer and rancher in Florida gets a Greenbelt exemption. The Greenbelt's only going to apply, that agricultural classification is only going to apply on land for farmers and ranchers that are engaged in a business enterprise. There has to be an intent for profit for your operation to be able to get that Greenbelt classification. Same thing applies to the agritourism operator. Now, operator, compensation or not compensation is not required, but nonetheless, you have to be in the business of it. And that's important in terms of the legal hurdle you have to have your Greenbelt. But also, when we talk about best practices, that's going to be important too, is how do you demonstrate your business as an agritourism? How do you demonstrate your business as a farmer and rancher? And how do you relate those two together to give the best possible case you can to the property appraiser or the county or your tax advisor or whatever you have to do with in terms of separation. So we'll talk about that as well. And I say this because what is agritourism? A lot of times we think it's pretty straightforward, but we also know that there could be a lot of gray in it. And I kind of just throw this out there as kind of a hypothetical just to show it, right? We got folks out here that are visiting a farm, getting educated about how cows, work with the farm and ranching opportunities and whatnot. Clearly agritourism. We're inviting the public to come here to learn about cow-calf operations, and we have the rancher giving us information about it. Absolutely 100%. Will be agritourism 10 out of 10 times, right? If you go to a hotel and they just happen to have a huge aquarium and you have a bunch of fish in there, right? 100 times out of 100, not going to be agritourism, But what happens when you combine the two? What happens if you have a hotel in an area that you have an exotic, ranch, farm and ranch operation, and people are invited there primarily for the purpose to enjoy and experience what it's like to be on an exotic game ranch, right? Now we're kind of in a bit of a gray area. Now, at the end of the day, in Florida, probably not going to be agritourism, but it just shows you that it very easily, you can take two concepts and get something in the middle, and you can have a bit of a gray area. And that's why the definition is a really powerful definition and a very risky definition, because the definition gives us a lot of move. What is an agriculturally related activity? What is a bona fide farm? What does it mean to invite members on the public? There's a lot of play in there. That gives you a lot of freedom of movement to develop your agritourism concept for your particular property. You're not pigeonholed into wedding barn or corn maze or U-pick, right? The law in Florida gives us a lot more room to do that. But it also, the more room you get, the more potential gray and the more potential implication, potential risk you have of running into conflict with either property appraisers or regulators or and whatnot. So again, it's something to keep in mind. But why do we want the agritourism designation? We want it for two reasons. The first one is we all want that liability shield you have under 570-88. That's always very important. And then what do? We also want that preemption we get from local governments, right? So you want to be able to have the legislature created this, a space that says we're not going to overregulate this particular activity because it has a particular importance to the state, and they highlight and they we legislatively made that distinction, right? And the important part for us is specifically for preemption issues, you have to have land classified as agricultural under 193.461. So you absolutely have to have your green belt in order to be able to get that preemption. For the liability, you don't have the same issue, but you still have to have a bona fide farm. What's the best way to have a bona fide farm? Is to meet the bona fide farm requirements under 193.146 to get your greenbelt classification. So it's very important. And you're going to see that we're going to use a lot of common terms between the agritourism law and the agricultural classification law. And that was done on purpose, right? The agritourism laws came in after the Greenbelt laws. Those terms were taken in large part from the classification laws, ironically to minimize the potential friction between adding agritourism overlays on top of agricultural lands and avoiding a lot of the issues we still face with property appraisers, right? The intent was to marry these two statutes up. In some ways it works, in some ways we still have some problems with some property appraisers. So that talks about agritourism. Let's talk about it from the agricultural classification side, or the Chapter 193 side. So as many of you know, now not all of you may have your greenbelt. There's a number of reasons from a tax standpoint, from a liability standpoint, from a business management standpoint, you don't have a greenbelt. Like you'd rather have your homestead extension. The homestead is more important for whatever reason than having your classification. So not everybody on this call may have it, but I'm assuming most of you do. And as you know, your greenbelt is not a guarantee. You have to get it every year, January 1 of every year. There's an assessment of whether you're engaged in an agricultural operation. Property Appraiser gives you a thumbs up or thumbs down, and it happens every year. And that's done with your filings before March of each year. There's a couple of exceptions to that March deadline, but for the most part, you get your cards in the mail and you resubmit to recertify your status as an commercial agricultural operator. And we do that before March 1 of each year. Now, let's talk about how that classification works. So that classification is going to work. You're going to be ag lands if it's used primarily for a bona fide agricultural purpose. So again, bona fide shows up, we draw from it directly and we 570. And that the term bona fide is specific statutorily defined to mean good faith commercial agricultural use of the land. Primarily for bona fide is going to be agricultural purposes is going to be really important. What is the predominant use of your property? Is it agritourism or is it agriculture? That's an important distinction property appraisers make in making that determination. And then also, are you engaged in good faith commercial agriculture? Are you actually a farmer and rancher, or are you acting like a farmer and rancher? That's something property appraisers take into consideration and care about when they make that determination. That determination is not out in the blue. There are a number of factors that they have to consider, and they're listed there. I'm not going to go into them. There's also an administrative code that expands on those factors. Again, we're not going to jump into it. I will make one code reference. There is one code reference that provides a little more meat on the bones for what good faith commercial agricultural use means. And that's going to be the pursuit of any agricultural activity with the expectation for a reasonable profit, or at least a reasonable expectation of meeting your investment cost and realizing a profit. So when we talk about Greenbelt, you need to be a commercial farmer or rancher. Doesn't mean you have to be profitable. In fact, many of us are not profitable on a year-by-year basis. And in fact, that's one of the reasons agritourism laws was created, was to supplement the incomes to allow farmers and ranchers to continue that hundreds of years of tradition in Florida of preserving this unique way of life. So it doesn't have to, but you have to have the intent to do it. And the intent and how you realize it and how you're supposed to be valued or compared and judged against is going to be based on the investment that you make and the expectations you have of making a profit based on that investment. It's going to be from the standpoint of the individual fee owner. It's not going to be a reasonable person test. It's not an objective test. There's not going to be a litmus test for what cow-calf operators in Okeechobee do versus those who are in row crops in Martin County or something like that. It's going to be based on the individual property and the individual farmers and ranchers and what expectations they have based on the investments they've made on the property. So that's an important factual distinction to make. So that's what you have to do to get your classification. Now, there's only two ways a property appraiser can take away your green belt. And that's if the land's diverted from an agricultural to a non-agricultural use, or the land is no longer being utilized for an agricultural purpose. And then there's a definition for what agricultural purpose means. And so where it comes into play with agritourism operators is a property appraiser is going to say, hey, yeah, I think your agritourism activity is now the predominant purpose on the land. It's not, the land has been diverted to a non-agricultural use. Your agritourism, call it whatever you want. That's really just a commercial activity as any other commercial activity. Therefore, I think you're now using the property for a commercial purpose, not an agricultural purpose. And therefore, I'm going to take your classification away in this year. That's a common fact scenario that comes up with property appraisers and agritourism operators. So how do we know what the predominant use of the primarily, or that phrase primarily for a bona fide agricultural purpose means, right? There's a case in Florida that we often use that gives us some common law guidance as to what primarily means. In this case is a 1972 case out of the 4th DCA, still used to this day. And basically what it says, the primarily simply signifies that the agricultural use must be the most significant activity on the land where the land supports diverse activity. So this is what comes into play when you have multiple uses on your property. If you're just a farmer and rancher and that's the only activity, then typically you don't have to worry about primarily bona fide agricultural purpose, right? Because you only have one activity on the property. Now, whether it's a commercial purpose, whether you have a profit motivation or not could be at question, but otherwise in terms of competing land uses, it's the only one. When you add agritourism, now you have multiple uses on that property. And now that question has to come, what is the primary use? And in order to keep your green belt or get a green belt, right, that primarily use, the most significant activity is going to have to be that ag operation. The term bona fide, statute goes on further to say is that the requirement the agricultural use be real, actual, or genuine in nature, right? So the predominant use, the most significant use on the property has to be your agricultural operation, which is consistent with what the agritourism definition provides, right? Because it's an agriculturally related activity, right? Agriculturally related activity, which means it's an activity dependent on and derived from an agricultural activity, an agricultural underlying agricultural operation. And that makes sense here because your primary activity, the most significant one, is going to be that underlying agricultural operation. And that operation needs to be actual and real. It means that's your intent. You're not acting as if you're engaged in these agricultural operations. You're actually doing it. And the way we know you're doing it is that you're able to demonstrate that you're doing it for a profit motive based on the investment you have on the property. So that's a very important link between the two. So where do we come up with problems? There's 4 scenarios that we routinely see with property appraisers. And again, I'm going to tell you, it's a minority number of property appraisers in the state that I have clients that have issues with. Most property appraisers don't have any problems with agritourism or agricultural classification, or seeing the fact that these two are mutually advantageous, mutually supportive activities. But there's a handful out there that have, under certain circumstances, given us problems. And the most common one is the property appraiser denies your classification on property with a historical classification after the owners begin agritourism activities. You've been a farmer and rancher, PA's had no problem giving you classification every year. All of a sudden you have a wedding barn out there. Now you're not agriculture and they pull it. the property appraiser denies agricultural classification only on a portion of the property containing the agritourism activity. So, you have a barn, you start hosting wedding events in there, and then the property appraiser goes, you know what? The back 70 acres of your property where you got your cow-calf operation, not a problem, but I'm going to take the 2 acres that's your barn and pull that out because now I don't think that's the primary purpose anymore. Then the third issue is the property appraiser denies an agricultural classification on a property where the owner is applying for the classification for the first time because there's an agritourism activity on the property. So you either acquire a property that's vacant, you start developing your agricultural operation, you simultaneously are doing your agritourism operation at the same time, you're asking for your classification for the first time, and the property appraiser says no, because I don't think you're really engaged in the bona fide real your primary purpose isn't to do agriculture, your primary purpose is to do a commercial activity called agritourism, so I'm not going to give you your classification. And then the final one I see least often is property appraiser denies an agricultural classification after an owner purchases the property and plans on offering agritourism activities in the future, and the denial is that the agricultural activity is not a bona fide purpose. So there are a handful of instances. In fact, the 1972 case I just talked about was that was the fact pattern is you buy an agricultural property, you're running it for an agricultural, you're using it for the same agricultural purpose that the prior owner was doing, but you present a business plan to the property appraiser, or you start a website that says, hey, coming soon, we're going to do these agritourism activities. And there are a handful of circumstances where the property appraiser will say the intent to use the property for a non-agricultural purpose, quote unquote, in their mind, means that your current use of the land is not intended to be commercial agriculture, and therefore I'm going to pull your classification, even though you haven't done anything different. It does happen, not particularly often, but it does. So what's the answer for these common problems? And that's what was done last year with the great work of Lena and the Florida Agritourism Association lobbying on your behalf to get this law passed. 57087 was substantially amended to try to address a lot of those these common problems that we just talked about, and by making it very clear to property appraisers that the mere presence of agritourism activities on agricultural land is not going to be a basis to deny or revoke a Greenbelt classification. We specifically added that language into 57087 to say, listen, property appraisers, when you see agritourism on the property, that alone is not going to be a basis, right? There is a proviso in there, so long as the building, structure, or facility is an integral part of the agricultural operation. So what does integral part mean? That's going to be the really important thing you have to look at going forward. So basically, the law was changed to deal with property appraisers that were removing agricultural classification because of the presence of an agritourism activity. So instead of fighting through 193, 146 on what is predominant, what is significant, we wanted to give some statutory direction. We want the legislature to give direction to the property appraisers instead of having to fight out through these bits. You can just look to 57087 that says, no, we're not going to do that. And again, you're going to get that protect, right? It's pretty clear to property appraisers that you're not going to go after Greenbelt simply because there's agritourism, right? The issue now is you got to be able to show that integral part, right? And what does integral part mean? And that can mean a number of different things. And we're going to talk about that in some of the best practices. But one way to look at this is a recent opinion that was offered by the General Counsel for the Florida Department of Agriculture and Consumer Services, or FDACS, right? There's a great provision in Chapter 570, the agritourism law, that says that FDACS can provide guidance opinions to local governments. And one of these great benefits, and some of my clients have utilized it, and I've utilized it, is you can actually, write to and call FDACS and say, hey, listen, can I get an opinion on the particular facts of my circumstance? And can you give that to the county planning, planning and zoning commission? Could you give it to a property appraiser? Could you give it to a fire marshal, or whatever it is? If you have an issue with interpretation of 570 and how it relates to local governments, there's a provision in the agritourism law that FDAX is there as a resource to give some guidance. And so late last year, we had some guidance on what that integral means. And I think this was a really great interpretation of the new law in 57087, what we just talked about, on what integral means. And integral wasn't, and they took a very broad, but I think very correct interpretation of what integral means. And that says that agritourism activities is an integral part of agricultural operation. It serves an important and obvious revenue function, and as well as a valuable marketing tool. So the presence of agritourism is integral to the underlying operation in order to sustain the operation. Now, a more narrow reading talks about, well, if you've got a structure, for instance, a barn, for it to be integral, that barn needs to be a working barn for your ag operation, as well as capable of supporting your agritourism activities, right? That's often been the common, approach that we've moved with on property appraisers in particular, and then also with zoning issues and code enforcement issues and building code issues. But it's important to realize that FDAX, at least as of November of 2022, took the position, a broader position, that integral means how the agritourism operation connects with your underlying farm or ranch operation. And if it's value added, then it's integral. And if it's integral, then the presence of that agritourism activity cannot be a basis for the property appraiser to remove your greenbelt. So very, very powerful interpretation, and I think a really correct interpretation of what we were trying to do in amending 57087 to give clarification and guidance to both property appraisers and agritourism operators and farmers and ranchers on how agritourism fits in and supports your greenbelt. So that's the big lift from last year, and we're seeing how that plays out now, because now that law became effective as July 1. So in many instances, classification determinations and denials that were done prior to July 1's question, it's kind of an open question as to whether the new law applies or doesn't apply. But now for 2023, January 1, entire new cycle, this is the law of the land. And I think if more property appraisers recognize the interpretation that was done by FDAX in this particular instance, I think it's going to be very, very good for agritourism operators going forward. So just very quickly, some best practices that I see with my clients that have been able to successfully navigate issues or disputes with property appraisers. So the first is the most conservative, is be farmers and ranchers first. So the more your property and more your agritourism activity is integrated and consistent with and basically a farming and ranching activity, the less likely you're going to have issues with property appraisers, right? And I don't think that's the most conservative interpretation, right? But if you're just looking to be very conservative, I don't want to have risk. Make sure you're farmers and ranchers first. And that's important because at the end of the day, that predominant use, that primarily bona fide agricultural operation is going to be the test. And so the most significant use on your property is going to need to be that farm operation. So the more that's evident, the less problems you have. Provide property appraisers agricultural management and business plans and periodically update. There is a provision in chapter 193, 146 that says property appraisers can make demands on a property owner to provide information to them to allow them to apply the factors to determine whether you get an agricultural classification or not. They can ask you for information. So one of the best ways to do that is to have a written agricultural management and business plan. Here's my agricultural operation. Here's my business plan. Here's my investments. Here's my anticipated profits. Here's what I've done before. Here's what I'm going to do. You can get I'm not saying you have to open up your accounting books, but if you're filing your Form Fs with the IRS, that same information you're providing in that Form F can get built into a business plan, and then take that to the plan, sit down with the property appraiser, present it to them, and then periodically update it as you change or modify your ag operation and your agritourism operation, right? And build that into it. Create a family of businesses and accounting practices that distinguish your agricultural operation from your agritourism activities. This has a liability shield benefit too. So, set up your enterprise in such a way that you can clearly show a property appraiser, here's my profit motivation as it relates to my underlying farm operation, and here is my business model for my agritourism activities. So even if you're running your agritourism activities as a not-for-profit, right, you can still have a, for my clients that are successful with this, have a way of documenting and separating this entity, this not-profit for entity or profit entity, and how it's distinguished from, but related to your business operation, right? And again, separating your agritourism operation from your underlying farm operation has some liability shield protection values as well. So I often have clients that have ownership of their farm in one particular entity. They have a farm operating entity, and then they have a lease and agreements, and they have arm's length transactional agreements that then set up their LLC or their not-for-profit for the agritourism activity. And you have all those distinctions. Each one of those have their own independent basis for demonstrating how they're either profit motivated or business motivated, depending on if you're doing a not-for-profit. I always think it's good to obtain letters of agricultural exemption from your local governments, right? So a lot of your structures on the property are going to be ag structures that are going to be exempt from the building code, right? Get a letter from the building department that verifies, yeah, that farm is in fact is an agricultural structure exempt from the building code. Anything that you can show a property appraiser that your structure is actually has been recognized by another entity as an exempt farm structure is going to help bolster your argument that that barn is a barn and it's not a wedding venue. That's often the distinction you have when you're dealing with it. Design and operate your structures so they have dual agricultural and agritourism use, or implement a site design where a single purpose agritourism facilities do not distract from the underlying agricultural operation. So I tell a lot of clients, listen, have dual structures, right? Have if you're going to do a wedding barn, have a barn that you're going to use for your underlying ag operation, size it for your ag operation, use it for your ag operation, and then add in your agritourism activities and then build out to support your agritourism activities. Now, based on the FDAX letter back in November of last year, I think you can now have single purpose, you probably always could have single purpose structures, but make sure those structures are integrated within your site in such a way that doesn't distract from your underlying agricultural operation. And how do you know it doesn't distract from it? Build it into your business plan. Show your business plan that you're not adversely impacting your profitability to operate that commercial farm or ranch operation. And then don't be afraid to engage with property appraisers. A lot of them have open door policies. Some property appraisers are more sophisticated in agricultural activities than others. Most of them are going to have staff that have a staff person that focuses on agricultural classifications. Make sure you're interacting with that person. And then finally, at the end of the day, don't take property appraisal denials on face value. A lot of people just lose their Greenbelt and they move on. I highly encourage folks to file an appeal to a value adjustment board. There is an administrative process to appeal the decisions of property appraisers. A value adjustment board is a layperson board, usually made from a combination of county commissioners and board supervisor representatives. Most of them don't really have a lot of interest in serving on the value adjustment board. It's an additional duty on top of whatever else they have to do as an elected official. And value adjustment boards may or may not just, kind of rubber stamp what property appraisers to do. But you never know. And I always think you need to take that next step. If the property appraiser disagrees with you, then go to the other people that are elected officials in the community and take your case before them. Depending on how you want to do it, it can cost you nothing. You just go there yourself and represent yourself pro se. You can hire an attorney to take you there and go through it. So it can be a very cheap proposition, or you can, and if you have the mechanism and the means and the desire, you can hire professionals to assist in that process. So those are some of the best practices that I see in light of the recent changes that were done last year. And I try to give you some context on why we did those changes by looking at the agritourism law by itself and looking at the agricultural classification law as well.
Timothy, hi, it's Sarah. We have a question. is adding value to agricultural product agriculture or something else?
Adding value. So I guess I need a little more context. Now, there is a provision in the law that says wholesaling, distribution, the commodity movement of agricultural products is not agriculture. So adding value to something, and I'd have to know a little bit more about it. But there is a distinction for that classification that the processing of agricultural products is not agriculture. So a good example is, if you're processing oranges, that's not a citrus grove. And so a processing facility may or won't have a classification. If you have a processing facility that's on a citrus grove, that portion of it usually gets excluded. Not in all instances, but typically that's going to be excluded.
Okay. Should a property appraiser label or call an agricultural structure? Are there certain codes that are used for non-residential ag buildings? Her pole barn has been labeled a clubhouse because it is an agritourism pole barn. Is that a problem?
Yeah, that's typically how it works with property appraisers that have an issue with agritourism on a particular property. So they will see again, they'll see a pole barn, they'll see typically a pole barn, they'll see a pole barn, and they'll look at it. And for agricultural classification, now understand what they're looking at is they're looking at the dirt, right? They're looking at not necessarily the structure, but they're looking at the land. How is the land being used? So the land that's underneath that structure, is it being used predominantly for an agricultural purpose? And the most common scenario is the property appraiser will look at a structure and go, you know what, that wasn't built to serve the land, that was to serve your ag operation, that was served so you can invite the public in to do weddings and events. And so that's a hall, that's a wedding venue, that's a commercial structure, that's a hall, that's not a barn. And therefore I'm going to exclude the acreage underneath that structure and the curtilage. And again, I think that's wrong. I think that's a misinterpretation. I think that's going to be a more difficult argument for them to make in 2023 with the change to 570-87. And here's why. And again, there's a bit of a trade-off in 570-87. I forgot to talk about this, right? So you can get, so long as your structure is integral to the land and it's being used for agritourism, that agritourism structure cannot be the basis for a denial. Now, the flip side, the trade-off is the fair market value, the fair market value, well, the actual term is, let me get it here, the just value of that structure is going to be added to the agricultural assessment of the value of the land, right? So if, a lot of folks will upscale their barn to be able to sort agritourism activities. They're going to do a bunch of improvements to the barn to serve their agriculture, to serve the agritourism purpose, right? That increases the value of it. Now, when the property appraiser, the whole purpose of getting your ag classification is substantially lowers your tax base on the land itself. And so now what will happen is, and you don't do it based on the just value, your agricultural classification is not based on the just value of the land, right? Which would be the potential value of the land if it was used for its highest and best use. Almost always that's never agritourism, agriculture, that's going to be residential development or commercial development or something other than that. So it's your classification is based on the actual value of the land for its agricultural purpose, substantially less value. But now your barn that you use for your agritourism activities is going to be assessed at its just value, which is usually going to be higher, and that's going to get added into the agricultural assessment. So your agricultural assessment is going to go up based on the improvements at your just value assessment of your structure. So in that particular question, it's a long way of saying, yeah, that's a huge problem, right? They're misidentifying what that structure is. They're not recognizing 587, and also understand that that structure is going to be assessed at its just value and built into your agricultural classification.
If a farm structure is classified by property appraiser non-agricultural use, will that structure have to be brought up to code for occupancy?
Potential, right? So now, so property appraisers don't deal with how you use the structure. They just know based on what they say you're using it for, and making a determination on your tax class, classification for tax purposes, right? Whether that structure has to comply with the building code, right? That's when we start dealing with the county or the municipality that you're operating in, and the local adopted Florida building code, zoning requirements, and other site plan requirements that may apply. Now, if that structure is agricultural and it's on land that's Greenbelt and it's agritourism, then there's a preemption from local governments from applying those standards, right? If you don't have that, you're at risk of the county coming in and saying that's not an agricultural structure, you're not on Greenbelt, therefore it's subject to local code, building code requirements, zoning code requirements, land development code requirements, site planning requirements, fire code requirements. There's a caveat is just because the property appraiser says, I don't think that's an agricultural structure, if the county recognizes it as an exempt agricultural structure, there's a different law that says, farm structures are exempt from the building code, for instance. So the county could say, I appreciate the property appraiser saying, I don't think that's agriculture. They're just dealing with the land. We think that's a barn, looks like a barn, therefore we consider it an exempt structure. If it's an exempt structure, then you get it. And that's something you want to deal with, directly with the county. You're going to say, hey, county building code or, building department, I want confirmation that this is an exempt agricultural structure.
Okay, did we have any other questions for Timothy?
That was a lot of information to unpack. We are here to further assist you with any questions after this webinar. And we also welcome any recommendations you have for future topics for webinars. We can certainly bring Timothy back. This was a pretty monumental year for us last session, and we'll be going into the 2023 session. And if any of you happen to be in Tallahassee on March the 8th, that's the Florida Farm Bureau Day. It'll be a good time for all, and we will have a booth, so please stop by. Any other questions, Sarah?
There is one. You mentioned county a lot. Does being within the city work as well?
Yes, and you just deal with the municipality that you're in. So
perfect.
Okay. Well, thank you so much, Timothy, for your time today. Thank you, everyone, for joining us. And we will catch you for the next webinar.
Thanks, everybody.
Bye-bye.
Thank you.